Hello everybody. Welcome to another edition of We're in Greater DC, and yes, it is a wonderfully happy day, especially if you're not in short sale land. Get outside and enjoy the nice summer weather here in April. As everyone knows, we film all over the Greater Washington DC-Baltimore region, different location each week. The first person to correctly guess and send that guess to support at Cornerstone Properties, homeinfo.com. Our filming location gets a free prize, whatever we're giving away. So take advantage of that. Also look on our website, capitalshortsale.com. Lots of free information and other giveaways. We just had a great lunch and learn and had a lot of fun at Pancho and Pepe's last week. So be on the lookout for that. The next lunch and learn that we're having free lunch for everyone who wants to come out. So we're talking about when a short sale bank can get away with anything they absolutely want to, even after short sale is closed. Yes, that's right. We had a short sale that was approved, approval letter, legally enforceable document. It was an approved deal. We went to closing. The HUD was even approved. And it turns out the lender said, oh, wait a second, we made a mistake. We got to revoke that HUD. We got to revoke the approval letter. We got to change the terms of your deal post-settlement. Can they do this? Absolutely, they cannot. The approval letter is legally enforceable, and most title companies will say that their title insurers will rely on that HUD approval and go to the mat. Unfortunately, in this case, we had Freddie Mac on the back end, and so it got a little sticky, unfortunately, we ended up caving. But as a general rule of thumb, your approval letters are legally enforceable documents. They will sometimes have a revocable provision, meaning if they see some fraud or some change of terms in the deal, or some sort of stipulation that has been violated as part of the short sale process, then they can revoke the approval at any time. But otherwise, it's a legally enforceable document. If the conditions are satisfied, that's it. What was interesting about our deal is that it got escalated not just to Freddie, but also to in-house counsel at the servicer, and of course, they're going to take a very aggressive tact, even over a very small amount of money, and really put the weight on the parties who are just us little people out in the field. And so you can make all the good legal arguments that you want. At the end of the day, even title insurers cave because they don't want to take on the really big boys. And it's a shame to the parties, because obviously it prejudices them if we have a change in terms, and it's a shame to not just the when I say the parties, I mean of course the seller and the agents and the other parties involved in the transaction, but also the buyer, because it creates uncertainty in the title company and the buyer's lender. There's a lot of risk in that when you don't know if the transaction is going to get unwound, or if people obviously have money in the deal and it's been dispersed. What is supposed to happen with that money if you can't claw that money back, which is the case for us too. So sticky widgets, not a fun time, but you sort of stick through it, and you get through it, and move on to the next deal. So anyway, capitalshortsale.com, support at Cornerstone Properties, homeinfo.com for your guesses. Don't send it anywhere else. Just support at Cornerstone Properties, homeinfo.com. We'll let you know on the next lunch and learn. And keep in mind, we're always looking for short sale rehabs. So if you got a property that needs a good amount of rehab, get in touch with us, because we may be interested in buying it as well. So long for this week, and enjoy the good weather. Bye-bye.